morning.
All right, good morning. And Mr. Tangway is here as well. How are you, sir?
Good, Your Honor. Thank
All
you.
right, good. Everyone go ahead and have a seat, make yourselves comfortable. Why don't I have both parties, wherever you physically are, go ahead and raise your right hand, if you please. Do both of you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do, Your Honor.
I do.
Okay. All right. We have a motion and an objection that we're dealing with today. I'm going to turn right to it. Both parties will have 15 minutes to argue their positions on this motion and objection. Let me just get it right in front of me. Stand by. The court has it in its file as number 33 and number 34, the petitioner's motion and the respondent's objection respectively. All right, without further ado, Attorney Ames, why don't you point out the important points in your motion and what you're looking for the court to do at this point.
Sure thing, Your Honor. This motion was filed back in January in response to a slew of pleadings that have been filed by Mr. Tangway. And through that process, he is requesting that the clerk's office forward all pleadings on his behalf to my office. And there was one pleading that I had contacted the clerk's office, the call center, and learned had been filed but hadn't received a copy of. And when I contacted the clerk's office in Manchester, they verified that 2 copies of the motion were found in the file and assumed that one didn't get sent out. So they sent it out to me right away. This is through no fault of the clerk's office. I just felt like it was important to file a motion to perhaps create a process and streamline the way that pleadings are being filed. I have a copy of the case summary in front of me, and in the parenting case alone, Mr. Tangway has filed 13 pleadings since November. 9 of them were in January and February. And in the domestic violence cases, there was another 8 pleadings filed by Mr. Tangway, either responses, motions, addendums, affidavits. I can't remember, there was a name of one that was something about the Civil Rights Day filing, and there's just so many pleadings in this matter, and unfortunately all 3, sometimes even the Supreme Court docket numbers are put on there. And just to remind the court, there is the parenting case, and then there are 2 DV case docket numbers. And so with all of these different pleadings, with all of these different docket numbers that are put on the tops of the motions, I think the process for filing has become a little burdensome frankly on the clerk's office. And so under Rule 1.23, we're simply asking that Mr. Tangway mail the pleadings directly to us. We're not looking for anything more than that. We just think a streamlined process of if he wants to file a motion, then if he wants to drop it at the clerk's office, he's certainly free to do so. But we would request that he go ahead and then mail the pleading to us to relieve the clerk's office of the burden of having to forward the pleadings, number 1, and 2, to reduce the amount of interference and being the middleman that the clerk's office has to do when what happened in January was a pleading, because there are so many, did not get sent to my office, or at least I didn't receive it if it got sent. And so, this isn't a life or death motion. This isn't a huge situation, but at the time, the reason this was filed is simply just to make the burden less on the clerk's office, as there are lots of cases in Manchester, and I'm sure their time could be used elsewhere. So those were the reasons behind the filing, and I'm happy to reserve any additional time for a rebuttal, but that was our thought process in filing this motion, Your Honor.
Okay, thank you. Mr. Tangway, please go ahead.
Yes, Your Honor. According to Rule 123, pleadings number 2, it states, a no contact order in a domestic violence, stalking, or similar matter shall not be deemed to prevent either party from filing appearances, motions, or other appropriate pleadings with the court. At the request of the party filing the pleading, the court shall forward a copy of the pleading to the party or counsel on the other side of the case. So that's why I've been filing through the court, because they filed what I have always stated, a frivolous and false domestic violence petition. And so that's why I have filed, and Attorney Ames should have already known about that. She's kind of being a little mischievous, I would say, with the intent. If you look at her motion, it's not just she's kind of backtracking to streamline the process. She, in number 5, she complains about during one such delivery, Mr. Tangway approached the underside counsel's assistant in the back parking lot of the Manchester office, making the assistant uncomfortable and fearful. She then used that, which happened several weeks after the fact, to file the petition for domestic violence. And she used that in the petition that she wrote out for her client, and then gained custody.
The DVO's already been adjudicated, sir. Why don't we talk about what we can do in this case so that both parties can flexibly and appropriately send pleadings to one another without putting additional burden on the clerk's office. What would you like the court to do, Mr. Tangway?
I would like the court to acknowledge Rule 123-2 and continue to submit the pleadings until we do settle in Supreme Court with the domestic violence petition.
Why?
Because it is more convenient for all parties. It ensures that all parties are able to, there's nothing else put into the mailings. It is done by the clerk, so if you have to file every pleading, so then the clerk sees it, and I can't be accused of, I don't know, putting something that was not in there. They could say that I put in a threat. There is a reason why this rule exists when it was made in 2011 at the beginning of the family division. And with consideration to that, I would like to continue to apply that rule. And also they mentioned hand delivery, and I think hand delivery is much more convenient. And Patty Ames complained about the hand delivery only as a function to file the domestic violence petition. She made it a bigger deal. It says hand delivery 6 times in the family court rules, and I mean that's pretty much it. The rules are clear. I've done everything in accordance with the rules. She filed this motion frivolous, and is just to slow down the process, and I don't think that it is good use of the court's time, and therefore a message should be sent to her that she can't just file and write all these baseless claims in with her motions and objections. And I'd like to be able to reserve the time to question Attorney Ames, as I did send a 5-day notification. I have documents here, and I'd like to get those on record, her standpoint for those documents, Your Honor.
Sir, you've been reminded multiple times that if you choose to engage in depositions of any of the parties, you are free to do so according to the court rules, but you're not going to turn this hearing into an ad hoc deposition of Attorney Ames. Okay, so your request to do that is denied. You can certainly reserve your time to make additional argument and presentation with regard to the motions, which is why we're here in the first place.
Thank you, Your Honor.
Attorney Ames, do you have any response to the things that Mr. Tangway has just said with regard to these 2 motions that we're entertaining today?
Yes, thank you, Your Honor. Again, with respect to the request for relief on the last page, these requests, I'm just simply seeking to have the court, my client and I would like to have this streamlined process that's clear. With respect to Rule 1.23b, I don't think the drafters anticipated that there would be 21 pleadings filed by a party in a 3-month period that would require the court's office to forward these. I think it has been made clear to Mr. Tangway throughout this process that he is certainly free to send pleadings directly to my office, and that would not constitute any violation of the domestic violence protection order. And again, my client's represented, so he's not even sending it directly to her, he'd be sending it to me. It is no different. I don't think it would slow down the process as he indicates. Frankly, I think it would provide the court with necessary relief, as they've had to send over copies of all of these pleadings. And for judicial resources, given the docket in the Manchester Family Division, there's already an overflow of cases. I think it just makes the most sense for if a party files a pleading in the court, it's their responsibility to mail it to any party that's listed in the court case. And again, there may be a guardian at some point, or maybe perhaps Mr. Tanguay will obtain counsel. But to whoever's listed as a party in the case, I just think it should be the obligation of both parties. Just as I do, I mail Mr. Tanguay the pleadings that I file. I think he should do the same.
All right, thank you. Mr. Tanguay, any further response on these motions, please?
Yes, Your Honor. Heidi Ames doesn't mail them out on time. She signs them, and those are the documents that I wanted to show the court. As I previously brought up, she says that she'll sign them and send them out on one day, and then she waits several days to send them out. In effort, as we're building a pattern of behavior, she's actually using the court's time inappropriately, and that's why the docket's so filled. She hasn't even filled out a financial affidavit. It's not signed. I actually have copies for everybody. The financial affidavit filed on December 19th for the hearing on the 22nd is not signed, and that's index number 20. You'll see I have copies, but there's the originals where it's not signed, not notarized, and not checked off in compliance with Rule 125A. I made perfect careful clarity with Mary Jo, one of the helpers at the court, to not take out the staples, and you'll see that the document is as it was submitted to the court.
Mr. Tanguay, what does that have to do with the motion and the objection that we're dealing with today, sir?
Well, I'm bringing up her possible impeachment. I mean, she's showing a pattern of misbehavior, which she's only doing because I am pro se. And she feels like she can get away with it, is my opinion. So we have a financial affidavit. She said just now that she mails out the documents, but I have Supreme Court documents where she said that she mailed it out on one date and then waited 4 days to mail it out. I have the postmarked envelopes, the original envelopes. All these things are building up a pattern of her trying to make me look bad and use the court system to burden me. And in fact, she has not gone to any mediation. And that's how this whole thing started out, is I asked the court to order mediation.
Sir, the reasons that the parties are not going to mediation, that's not why we're here today, sir. That was put very clearly in the court's orders, okay? We're here to talk about what the methods are for the parties to send pleadings back and forth and what is going to be efficient and least burdensome and mutually reciprocal on both parties. Do you have anything else you want the court to know with regard to those issues, please?
Yes, Your Honor. As part of the fairness of the rules, she is able to, because we're involved in domestic violence, file with the court and have the court forward it. It says it right there in the rules. Any party may ask for that. And that is done for a reason, to ensure that there is no fraudulent documents being filed, or documents, for instance, she could say, or I could say, yes, I got the paper, however, I also got a death threat in there, or whatever it may be. And with the history that you will see in the court record, she has not filled out the paperwork and not done her job. She has not filed a financial affidavit. I've asked the court numerous times, and I understand the court is very busy because I've seen the court with some very serious matters. But there's no reason to not have the court forward these documents in this particular case. And additionally, there was one other thing. Oh, she mentioned that she did not receive the paperwork, but if you look at the court record, that paperwork that she's discussing, it says stamped on it by a clerk, resent. That means she ended up getting your orders, Your Honor, prior to me. She got your orders prior to I received it, because they held those orders for several days. I don't have the very specifics on it, but if you look at if you actually look at the file, and if Your Honor would like me to, I can pull that file and submit it to the court and to Heidi Ames to also show that and prove that it was resent, not that she did not get it. That doesn't preclude her from not getting it. I mean, that's not 100% proof that she's lying, but there's a lot of weird stuff going on. Thank you, Your Honor.
Okay. Attorney Ames, anything else you want to point out to the court about the pleadings, numbers 33 and 34 in this matter?
No, Your Honor, at this point, I want to defend myself, but I don't think it's necessary. So I trust the court to make the right decision, whatever it is, for the process of the pleading.
None of
Thank
those allegations are relevant to why we're here today. Mr. Tangway is free to report you anytime to the Attorney Discipline Office and wherever else he so
Absolutely.
chooses. So with regard to the
Yep.
pleadings that were here today, I'll take another look at them. I'll review the court rules to see what type of appropriate relief the court may order both parties to comply with. So appreciate the parties' time in coming here and arguing this out. The parties will get the court's orders in the mail. Thank you both.
Thank you, Your Honor.
Appreciate it. Thank you, Your Honor.
Mm-hmm.